I found that a little bit curious. Now, the bit I'm least looking forward to, and no doubt you are as well, is to look at some of the key provisions. It's really worth a read if you've never stuck your nose in one of these things, and just to have a copy of it. Certainly probably the 04 one, which you're probably more likely to have clients that are affected under if you're acting for directors and guarantors. The key ones, I haven't put them all up on the slide, but 25.1 in the 2004 code. Before we offer or give you a credit facility or an increase in an existing credit facility, we will exercise the care and skill of a diligent and prudent banker in selecting and applying our credit assessment methods and informing our opinion about your ability to repay it. Now, other speakers will address that. My own thought on it is that it says what it says, and the courts have determined it, but as I think's become clear in the cases, you would have to go pretty far to find that the bank really didn't undertake the exercise at all. Whether or not they did it properly or not is a different question, and I think Simon will talk about that. But in my view, the clause isn't that specific. It really just means that they've got to undertake an assessment, and whether or not that's appropriate, having regard to all the circumstances, ultimately a judge might have to determine that. But I don't think it's as invasive as it sounds at first blush. Others may have a different view, but nonetheless, it's an obligation that's there, and banks ignore doing it properly at their peril. 28.1 I've not put on the slide, but it just states that this clause applies to every guarantee and indemnity obtained from you, where you are an individual at the time the guarantee and indemnity is taken, for the purpose of securing any financial accommodation or facility provided to us by another individual or a small business. And then there's a couple of carve-outs which I'm not going to descend into. But interestingly, the definition of small business, it hasn't, I don't think, ever been a real issue in any of the litigation, but it's a curious definition because it says small business is a business with less than 100 full-time or equivalent people if the business is or includes the manufacture of goods, or in any other case, less than 20 full-time or equivalent people. Now, it strikes me that people's a bit of an odd definition, and at least theoretically, if you had a small business that had a number of employees, but also, for example, a number less than 20, but also had some sort of contractors working, because the term is not employee, it's just people, whether or not you might be able to use that if you're acting for an affected business to mount an argument, but I don't think it's really been determined in the cases, but nonetheless it strikes me as an odd definition. Clause 28.4 is the disclosure provision that features heavily in the cases, and it covers the bank's obligation to give guarantors prominent notice of various matters. Again, that's for the other speakers to deal with. And also 28.5, we will not ask you to sign a guarantee or accept it unless we have A, provided you with information in clause 28.4, and B, allowed you until the next day to consider the information. Now, that's come up a lot too. I can recall, at least in one decision, I think it's the Wood decision of Justice Elliott recently, or perhaps another decision, that the courts have interpreted it, at least in one instance, as it's not going to make or break the case if they didn't have until the next day to consider, as long as the bank allows them. It's not a backstop time period. So, for example, if in the circumstances you have a guarantor who says, I've got advice or I don't want advice or whatever, and they're prepared to essentially waive their right to the next day, I don't know how much success you would have relying on it. It seems to be interpreted as just giving the guarantor the opportunity of the next day to read and consider. And again, that was the situation that faced me in a case I dealt with earlier, where the bank manager literally came around for a cup of tea, sign here and there, and away you go. Really, in conclusion, before these gentlemen talk about the more interesting cases that have made it up to the higher courts, a professor of mine at law school always used to say that credit lubricates the wheels of commerce, but it must be managed by security. And probably the reference might have been to a mortgage or a charge, but it nonetheless applies to a guarantee. But my view is that water's wet, the sky's blue, and lenders are always going to want guarantees from directors or other people. So this is not a problem that's going to go away. And I think even though the focus of this morning is the application of the code, I think we are always going to have work acting for, might be for a lender, you might be doing some front-end work drafting guarantees for a company for whom you act that, for example, gives goods on credit and so forth, or you might be acting for guarantors. They've started a business, the business has gone bad and they're now being pursued by the lender. Whether it's code related or not, there are the law of surety, or the law of modern contract of guarantee, is quite complex, and I think sometimes we sort of rush and don't consider the facts properly. But there's a lot of law. It's complicated, and I think when you're presented with this sort of situation, certainly I think one of the takeaways from this morning will be, if in doubt, plead the code, but consider more broadly the circumstances of the case and how you might be able to assist your client in negotiating an outcome. And again, if it is for a guarantor, bear in mind banks have got that PR component to what they do. That's not to say they're not going to pursue money that is owed to them, but often if you have a client who just doesn't have the money, the response might be, look, we think, Mr. Bank, Mrs. Bank, you've got some exposure under the code. There might be a Garcia defence, for example, the wife of the director. You can't get blood out of a stone. They've only got this much money anyway. I've certainly had a case where a settlement agreement exhibited a statement of assets and liabilities, and with the usual terms, if the bank finds out that they've got more than that squirreled away somewhere, all bets are off and they'll come after you again. But you know, I've had a client on the hook for $2 million, and needless to say, it was settled for far, far less than that, and the bank saw the utility having regard to its risk of accepting a lower sum. So all is not necessarily lost just because your client's done something stupid and signed a guarantee. So with that, I'll pass